So I am starting a trial that I came into at kind of the last minute, starting it next week. And I realized that making decisions on calling witnesses, treating doctors and experts live or using their video is really important. And so I wanted to talk about that process. And I want to start when you have discovery and you're trying to decide what evidence through treating doctors do I need? Well, remember that the California Code of Civil Procedure section for depositions is 2025. So when you talk to a judge, whatever, and you are talking about depositions, right, you're going to be talking about CCP 2025. In the different sections, they deal with different topics. For example, there's a section that talks about if you're deposing a party, you can use that deposition or the video at any time for any purpose, including you don't even need to call that party. If you just want to play their deposition at trial, you can do it. But another section deals with treating physicians, and that's 2025.220. And what it says is that if you take a treating doctor's deposition and in your notice of deposition, you say, I'm going to take this with the possibility of playing the testimony in lieu of live testimony under 2025.220. Then you can take a treating doctor's deposition, and now I need it at trial for Sanchez Foundation, for completeness, for the jury not thinking that I'm leaving out treating doctors. And as long as I properly noticed and took the depo earlier, I then do a page in line, I give it to the other side, they add what they want to play, and we can play it at trial. And so next week, when I start the trial, I'm going to short circuit the length of the trial by playing excerpts, and sometimes longer excerpts, of different treating physicians. But there's another section that deals with experts, okay? And we designate experts and we're going to call them live, okay? Now, I could also play their deposition under 2025.220, but I want to talk about the thing that a lot of people don't know as plaintiffs' lawyers that I find is really effective. There is another section in 2025 called .620, so 620. And I know this, and I have a pocket brief because a lot of judges don't, at least before they changed the law, if they were on the bench, a lot of them still don't know it. There is a provision now that if you take a defense expert's depo under 620, whether the defendant de-designates them, never calls them, whatever, you can place snippets of the defense expert's testimony in your case in chief, as long as you give proper notice and page and line. So for example, in this auto accident case, rear ender, 3-level neck surgery, shoulder surgery, and they have, a defense expert surgeon who poo-poos the EMG that found radiculopathy. Let's just say whatever it is. Right? In that depo that I took of the defense expert, I get him to admit, well, I use EMGs and I do it before every surgery and et cetera, et cetera. So I can take that snippet under 2025.620. And when my doctor is on the stand and talking about an EMG, I can say, and let's see what the defense expert says. And I play it. And then I'm like, hey, doc, you use EMGs. They use EMGs. This EMG says my client's hurt. What do you think about that? And it really puts stuff into context. And as I say, you're kind of anticipating what the defense is going to say. And then you put it up early, primacy. Jurors, like everybody, tend to decide early on if I'm going to put on the plaintiff colored glasses or the defendant colored glasses. And then they look at everything through that prism. And so I've gone through all of the defense experts' depots. I've pulled out the different page and line snippets that I plan on playing. I obviously have more that I've put than I will actually use. The defense has to have a certain amount of time to be able to respond back and say, well, if you play this, we want to play this. But those are the foundations for when you're taking treating physician and experts depositions, the types of things that you need to put in your notice, and understand that when you ask the questions, if there's a chance that you're going to play that testimony at trial, that's why you see in many of my depositions when I ask a question of a defense expert and they give me a yes, but blah, 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 blah. I know that I'm going to want to play me asking that question and getting just the answer. So I'll ask it again. And if they still won't listen, I say, look, I'm not trying to argue with you. I'm not saying you agree with this, but is it true or not X, Y, Z? Yes. Now I have that snippet that I can play, right? And so this is all about prep. Remember, 99% of all cases don't go to trial. But when they do, you need to have this stuff ready. And also, as in everything that I'm talking about, that silver lining is when you show the other side early in the case that you know how to try a case, that you know the foundation that is needed to get this into evidence, you are telling them what kind of leopard you are, right? And insurance companies realize that leopards don't change their spots. And lawyers that know what 2025.220 and 620 is are the same lawyers that know how to try cases, that spend money on their cases, that don't take bullshit offers, et cetera, et cetera. And the reverse is true. So I hope this helps on depositions of doctors at trial.